Ornelas versus the U.S. It's also decided in the same year as Grant 1996. This case was written by the Chief Justice at the time, who was William Rehnquist. Rehnquist was appointed to Supreme Court as a justice in 1969 by uh, President Nixon. President Nixon is a Republican. Rehnquist was a conservative justice. He was justice from 79 to 86. In 86, President Reagan elevated him to be Chief Justice because in 86, the Chief Justice named Warren Burger retired, and so there was an opening for Chief Justice. So Rehnquist was elevated uh, to be Chief Justice, and at that time, President Reagan nominated uh, a guy by the name of Judge Bork, B-O-R-K. Bork was the judge on the D.C. Circuit, but had come out and said there is no right to an abortion, there is no right to privacy in the Constitution, and Bork was, in order to become a Supreme Court justice, you got to have 51 senators approve you in the United States Senate. Bork was defeated in the United States Senate. And then President Reagan nominated a Harvard law professor named Douglas Ginsburg, who was also on the D.C. Circuit. During Douglas Ginsburg confirmation hearings, it came out that while a Harvard law professor, he was smoking marijuana with his students, and he at that point he said, "I don't want to find out. I'm going to back out of my nomination, not even try to get on the Supreme Court." So President Reagan nominated a third person, that was Judge Anthony Kennedy, who at the time was the judge on the U.S. Court of Appeals for the Ninth Circuit. And Kennedy was confirmed. And Kennedy served from 87 till Justice Brett Kavanaugh was appointed in the first Trump administration. So, Ornelas, so the defendants pled guilty to cocaine possession with the intent to distribute. If you have 2 kilograms of cocaine, uh, that indicates that you're a drug dealer because that's a lot of coke. And that's not for your personal use. And that's what it means to be indicted for possession of cocaine with intent to distribute, which you're a drug dealer. So they pled guilty, and if you plead guilty, you can reserve your right to appeal. So that's what they did. They pled guilty, they reserved the right to appeal after the district court denied their motion for arrest. The district court said there was reasonable suspicion to stop them uh, when they entered their car, and then once they entered their car, there was probable cause to remove the interior panels of the car, where the police found 2 kilograms of cocaine. So, on like the sides of the car, there's panels, and they can be taken off, and you can store drugs inside the panels of the car, like in your door panel, the inside of your door. So that's where the cocaine was found. So this went to the Seventh Circuit, and U.S. Court of Appeals for the Second Circuit. They said there reasonable suspicion to stop. There was reasonable suspicion to stop people, and there was probable cause to search. And they said that when we assess if there was reasonable suspicion and probable cause, that we're going to give a lot of deference to the district court who originally decided that, and we will only reverse district court if there's something called clear error. Clear error just means that we allow the district court to make its opinion, and we're only going to reverse it if the error is like a big deal. Rehnquist says that this appellate court should not use the clear error standard, but should use the de novo standard. De novo, G-E-N-O-V-O, de novo just means that whenever the appellate court looks at a case, they don't give deference to the district court. If they look at all the circumstances, they start from the beginning of the case, and the appellate court looks at all the evidence, and regardless of what the district court found, the appellate court could still reverse the district court, not based on clear error, but based on a de novo review. A de novo review is that it's like the appellate court is looking at the case for the first time, as if the district court hadn't even made a decision yet. Clear error is when you look at the case and say, well, the district court has already made the decision to allow this evidence to come in trial, so we're going to allow the evidence to come in trial unless the district court made a big error or it was a clear error. There's a difference between a de novo review and a clear error. De novo review just means that we're not going to give deference to the district court. We're going to look at the case with fresh eyes from the very beginning. Whereas a clear error is we're going to give deference to the district court, and we're only going to reverse this unless the district court made a huge error. It's a clear error. So Rehnquist rejects that. That's what the Seventh Circuit said they were going to do. But the Supreme Court, Rehnquist said, no, it's not clear error. It's de novo review. So the facts of the case, there was a detective, Potts, he was a 20-year veteran of the Milwaukee Sheriff's Department. So the Seventh Circuit is in like Wisconsin, Illinois, that part of the country. So this 20-year veteran of the Milwaukee Sheriff's Department had 2 years of experience in drug enforcement and drug interdiction, specifically in downtown Milwaukee. So when you're determining like what is reasonable suspicion, a probable cause, like in the Terry case, that officer in the Terry v. Ohio case, he had like 40 years experience in downtown Cleveland looking at people to see if they were suspicious. This officer has 20 years experience in downtown Milwaukee in drug enforcement. So he saw a 1981 two-door Oldsmobile with California plates in a hotel parking lot. And it was wintertime, and he thought that was unusual. He said that an Oldsmobile he was attracted to that car for two reasons. That it was an older model car, And he said two-door General Motors cars are a favorite of drug couriers because they have large doors. You know, a two-door car, if you've ever owned a car, it's a two-door car, the door is very big. There's a lot of room inside those door panels inside a two-door car to hide drugs or to hide other kinds of contraband. So that was one reason why he was attracted to the Oldsmobile. And he said California is a source state for drugs. There's a lot of drugs come from the state of California. Like a lot of drugs, especially cocaine, come from Florida. Uh, so Detective Potts, he radioed dispatch to see what about the car's registration. And the dispatcher told Potts the owner was either Miguel, can't pronounce his name, Desma Ornelas or Miguel Ornelas Desma from San Jose, California. And Potts wasn't real sure the exact names the dispatcher gave. So they went to the hotel, like the registration desk of the hotel, and asked them, well, who checked into this room? And the hotel said, well, it's Ismail Ornelas checked into this room. So the last name fits. And then the hotel registration says there was another man who checked into the room. And he thought it was odd that they checked into the room at 4 o'clock in the morning and they didn't have a reservation. So to him, that was suspicious behavior. So Detective Potts called his partner Daryl Hurley. Hurley had 25 years experience, and for the last 6 years he was on the drug enforcement detail. So when Hurley arrived at the motel, the officers then called the DEA, and they asked the DEA to run the names of these individuals through something called the Narcotics and Dangerous Drugs Enforcement System, or NADDIS. NADIS. NADIS is a federal database that the DEA keeps on suspected and known drug traffickers. And in NADIS, Ishmael Ornelas Jr. is from El Centro, California. The car has California plates. And according to that NADIS database, that Ishmael Ornelas Jr. was a cocaine dealer in Tucson, Arizona. So that gave them suspicion that this person who was driving this car, or at least one of the two people in the car, were dealing drugs and had driven to Milwaukee. So then they called Deputy Lukey and a drug sniffing dog named Merlin. So Merlin and Lukey show up at the scene, and then this detective Paz, who was the original detective at the scene, who really was the one who got the suspicion that these guys were drug dealers. So sometime later, we got the drug dealers left the hotel room and they got into their car, got into the Oldsmobile. At that time, Detective Hurley approached the car, approached the Oldsmobile, identified himself as police, and he asked them if they had any illegal drugs or contraband in the car. And they said, no, we don't. And then he asked them for ID, He was given 2 California driver's licenses with the names Saul Ornelas and Ishmael Ornelas. So one of the names matched the NADIS database, Ishmael. So then Officer Hurley asked if it would be okay if they searched the car, and he testified that they said it was okay to search the car. In other words, they consented for the officers to search the car. This becomes an issue later about whether they consented or not to search the car. Because at this point, they had reasonable suspicion to stop the men based on the NADIS database and the drug source in the car. From California, the Oldsmobile with the big doors that could hide drugs, and then their names in the database. And so Ludicky, the deputy, over the last 9 years, testified that he searched over 2,000 cars for drugs. And he said that when he searched the car, he said they consented to search the car. When he searched the car, he noticed that there was a panel in the rear passenger seat that was loose. He suspected that there was something behind that panel, that there were drugs hidden behind that panel. And he said the screw in the door jamb adjacent to the loose panel was rusty. It had rust on it. And Lukey said to him that meant that the screw had probably been removed. So he removed the panel covering the inside of the door, and he found 2 kilograms of cocaine inside the panel door. So Ishmael Ornelas filed, and his Saul Ornelas filed motions to suppress. They're trying to get the cocaine thrown out of evidence. They're alleging that the police violated their Fourth Amendment rights. One, they're saying they did not have reasonable suspicion to stop them. All you need is reasonable suspicion to stop somebody and conduct an investigatory stop. So they didn't have enough suspicion to stop and conduct an investigatory stop. Secondly, the search without a warrant violated their Fourth Amendment rights. Now, if you consent to the search, you don't have, you can't say you have Fourth Amendment rights that are violated if you consent to the search. So the defendants are arguing that they did not consent to the search. But the magistrate judge who heard the motions to suppress said that it was clear, the evidence showed that they did consent to the search. That the record clearly established, the judge said, that consent to the Oldsmobile was given with no restrictions. So with no restrictions mean you can consent to search the car, but you can say, I only consent for you to search the front seat of the car and the glove box of the car. You can't search anything in the back seat. You can do that. You can limit the consent you give on what kind of search the police conduct. But in this case, the officers say they got consent to search the car, and there wasn't any limitations around what on what they could consent to search. That they can search the whole car. So the government, meaning the police, they conceded that when the officers approached the men in the parking lot, a reasonable person would not have felt they were free to leave. So the government is saying that when the officers approached them when they were in the car, that was an investigatory stop, and that if you're not free to leave, that means you're in police custody actually, and so this was like a Terry stop where the officers had reasonable suspicion to believe crime was occurring, crime was about to occur, or crime had occurred. That's you can stop somebody based on reasonable suspicion if you have reasonable suspicion to believe crime has occurred, it's about to occur, or is in the process of being occurring. So Terry established this investigatory stop based on reasonable suspicion. You can stop somebody based on reasonable suspicion, but you can only search if you have probable cause. So they made the stop of the men based on reasonable suspicion, based on the navis and the plates and the two-door car in the middle of winter in California, California being a source state. And in Natus, the name matched the guy that was staying in the motel is a drug dealer from Arizona. And then they consented to the search, according to the police. So the magistrate judge said, the magistrate judge is like the district court, the trial court. The magistrate said the officers had reasonable suspicion to stop. They did not have probable cause. And the magistrate judge at the suppression hearing, motion to suppress hearing, said there was no rust on the screw, so Deputy Ludicky had an insufficient basis to conclude drugs would be found in the panel. So because he didn't have enough proof that drugs would be found in the panel of the car, that what he did was unreasonably and probable cause to search that panel of the car. So the magistrate is throwing out the evidence because there wasn't enough evidence of probable cause to search. However, there's a doctrine in law called inevitable discovery. Inevitable discovery. So if you're conducting a search and you're going to find the evidence inevitably, even if you violated some norms of legal norms conducting the search, if you're going to find the evidence inevitably, then the evidence can still come in. So the evidence, the cocaine evidence in this case was admitted to the evidence under the inevitable discovery doctrine because the drug sniffing dog was there. Regardless of what Officer Ludicky did, even though he didn't have probable cause to take that panel off, search that car inside that panel for the cocaine, the magistrate said that the dog would have sniffed the cocaine and the cocaine would have been found regardless of what Officer Ludicky did. So, under the inevitable discovery doctrine, the cocaine would have legally been found, and so it's in. So because of that, the defendant's motion to suppress were denied, so the evidence gets to come in. And then the district court adopts what the magistrate said, only with respect to the reasonable suspicion, but not the probable cause. So the district court said they're not buying the inevitable discovery doctrine. for the probable cause. They're just saying that there wasn't probable cause. Why? The district court held that the model of the car, the age of the car, the source state, together with two men driving the car, checking in a Motel 4 in the morning without a reservation, fit the DEA's drug courier profile. So all that with the Natus reports, that gave rise to reasonable suspicion there was drug trafficking. So the district court is saying there was reasonable suspicion to believe that Ornelas had or was involved in drug trafficking. But he didn't go as far as the district court said that reasonable suspicion turned into probable cause when Lukey found the loose panel. It's the cocaine they used for evidence. Seventh Circuit, because they're basing their opinion on clear air, not de novo review, said that it would only reverse the district court if there was clear air. The Seventh Circuit made two findings: that there was no clear air with respect to reasonable suspicion, but there was clear air with respect to probable cause. So the Seventh Circuit reverses the district court, and they didn't think Lunacci was very credible when testifying about the loose panel. They didn't believe him when he testified about the loose panel. So the evidence did not come in based on what the Seventh Circuit ruled. Then it gets appealed to the U.S. Supreme Court. That's when Chief Justice Rehnquist is. Now we're talking about what Chief Justice Rehnquist said. Rehnquist said that reasonable suspicion and probable cause are difficult concepts. They're very difficult to prove, very difficult to explain. And he said, best way to try to figure out what reasonable suspicion and probable cause are not technical legal terms, but just common sense. That they deal with his common sense and says like factual and practical considerations that apply. Just what would a reasonable, prudent, ordinary person think faced with this evidence? And there's no like legal technician who's determine what probable cause or reasonable suspicion is. There's no neat set of legal rules, and the Constitution even says that you got to have a particularized and objective basis for suspecting somebody is engaged in criminal activity. So whenever they talk about the Fourth Amendment, they always talk about the objective basis. This is just like in the Wren case. As long as you have an objective reason for stopping the car in Wren, then it doesn't matter what your subjective motivations are for stopping that car. If you have an objective, reasonable basis for stopping it, if there's any kind of traffic violation, you stop the car. It doesn't matter that you're stopping the car because somebody's race in the car or gender or whatever. So reasonable suspicion, you got a particularized means you have to describe in detail why you think the person is suspicious. If probable cause exists when there's facts that are known and there's circumstances that a reasonable man of prudence think there would be evidence or contraband in the car that a crime occurred. Reasonable suspicion is just based on you think there may be crime occurring or it has occurred or it's about to occur based on some particularized objective basis. Like in Terry, the two people or the three people on the corner talking, moving back and forth, looking in the store window multiple times. That created reasonable suspicion that crime may be about to occur. But that wasn't probable cause until the officer did the pat down, found the weapon. So they had reasonable suspicion to think that these guys were involved in some kind of drug trafficking. Probable cause is one step beyond that. Like I said before, reasonable suspicion is about 30 to 40% certainty somebody's committed a crime, whereas probable cause is like just over half, like 50.1%. That's all you need in terms of certainty. You're 50.1% certain somebody's committed a crime. That's probable cause. So, when a person, they always say command, but it's people. They don't mean just a man or a woman of reasonable prudence. Would they think that evidence of crime would be found in that car? In this case, in the panels of the car of the Oldsmobile. So he goes on to say these are not finely tuned standards. He says the proof beyond a reasonable doubt, proof beyond a preponderance of evidence are easier to determine than reasonable suspicion, probable cause. So proof beyond a reasonable doubt, I mentioned before, is about 95% certain that the person did it. Proof beyond a reasonable doubt is what you have to show if you're the prosecution to get a criminal conviction. And proof by preponderance of evidence is what you have to show if you're a civil plaintiff arguing that you should win a civil lawsuit against some defendant. He says those concepts are easier to understand than reasonable suspicion or probable cause. I don't know if I agree with that, but that's what he's saying here. And he also said that reasonable suspicion and probable cause are very fluid concepts, and you can have reasonable suspicion somebody's about to commit a crime, and then that can turn into probable cause very quickly. That's what he means by fluid concepts. That objective reasonableness to an officer amount to reasonable suspicion of probable cause happen very quickly. And now he gets into that we don't really review cases based on clear error. We review cases based on de novo review. So we take the whole circumstances into consideration whenever we decide the case. We don't base our review of whether or not the lower courts appropriately reached the decision based on clear error. We do it through de novo review. So that's what he's saying. The Seventh Circuit is wrong by giving the district court too much deference and relying on clear error. That it should be de novo review. Then he gets to the case, he said, police view the facts through the lens of police experience and expertise. But now he's going back to all these officers had decades of expertise. Being a police officer, but they also had many years of expertise searching cars. Detective Ludicky, he had over 2,000 cars he'd searched for drugs. So when he looked at those panels and he saw that loose screw, that rusted screw, that to him, that was an indication that there was something, any drugs behind that panel. To a regular person who never searched a car for drugs, that may not meant anything at all. But based on the officer's expertise, it meant a lot. So he says, well, it may not amount to reasonable suspicion at a motel located along Transcontinental Highway. The height of summer tourist season may not rise to reasonable suspicion in December in downtown Milwaukee. So he's saying that same car parked at a rest station, or a truck stop in the middle of summer somewhere, not give anybody suspicion that that same car parked downtown Milwaukee in December may rise to suspicion. So what he's saying is that circumstances matter, particularized facts matter, and the context of every situation matters. That context matters. When it happened, where it happened, what time it happened, what time of day, what time of year. All of that you have to take into consideration. Talk about reasonable suspicion or probable cause. Said it's cold in Milwaukee, so it's reasonable to infer that if there's a California car stopped in Milwaukee in December, they're either there to transact some kind of business or they're there to visit a family or a friend. And he said it was reasonable for the police to draw inferences based on their experience. Again, he's talking about all the experiences officers had at drug interdictions, just investigating crime in downtown Milwaukee. Very similar to what the Supreme Court said in Terry v. Ohio. To a layman, the loose panel of the back seat in a 1981 Oldsmobile may not mean anything, but to a trained detective, it may mean a lot. Because Lubicki had searched over 2,000 cars for drugs, it suggests to him that drugs may be inside that panel, but for a layman, it wouldn't mean anything. So, again, he said the appellate court should give due weight to a trial court in finding the officer was credible and the inferences were reasonable. Here he's saying that an officer who searched a car, 2,000 cars for drugs, is more credible than what the magistrate gave the officer credit for. That because he had all this experience, when he's testifying, that you have to take that into consideration. Again, context matters. If it's a rookie police officer who's never searched a car before, that's different than some experienced officer who searched a car 2,000 cars for drugs. You have to give weight to that officer's experience, credibility. Again, context is a big deal. Context matters. So he reverses Seventh Circuit and remands the case back to the Seventh Circuit, and he says, this time you have to look at the case not for clear error, but with de novo review, which means you have to take the whole case into consideration, and you can't say, well, I'm going to give deference to the district court, the trial court, and I'm only going to reverse the trial court or affirm the trial court if they made a clear error, which means a big error. So on remand, the Seventh Circuit, when they do de novo review, they have to determine whether that officer had reasonable suspicion, probable cause, escape. Rehnquist is saying thanks, say yeah. But he's going to send it back in the Seventh Circuit to let them make the final opinion or determination. What happens is the Supreme Court usually doesn't rule on the finality of the case. What they will do is they'll make their ruling and they'll remand. They'll remand it back to the lower court, let the lower court make the final determination on whether or not the evidence is suppressed or whether it goes into evidence. So that's an important point. Because the Supreme Court rarely says this person wins, although sometimes they say this person wins. But usually they make a decision and they overturn, in this case, they overturn and reverse They reversed the Seventh Circuit and they remanded back to the Seventh Circuit and let the Seventh Circuit make the final decision based on what the Supreme Court said. So, and usually the Seventh Circuit or any court that gets a remand from the Supreme Court, they they don't have a lot of choice in deciding what they decide. The Supreme Court is essentially deciding the case, but they let the Seventh Circuit make the final decision on remand. So that's Orleans versus